Hello viewers, welcome to my YouTube channel. My name is Naiza Babra, and tonight we are going to talk about adoption in Uganda. What is adoption? Who is supposed to or who is competent to apply for adoption? What are the requirements for adoption in Uganda? Kindly subscribe to my YouTube channel for more legal updates. Let's start by defining the term adoption. Adoption is the permanent legal transfer of all parental rights from one person or persons to another person or persons. So meaning adoption can be done by one person or two persons. You get that point? It can either be done by one person, it can also be done by two persons. The one family, man and woman, married couple, can come up and say, we want to adopt this person. It is allowed. And then a single person or one person can come up and say, I want to adopt this child. It's also allowed. So let us continue with our discussion. Adoptive parents have the same rights and responsibility as biological parents, and adopted children have all the emotional, social, legal, and kinship benefits over biological children. So the moment you adopt a child, it means that this person or the child you've adopted acquires all the rights as those of your biological children. In other words, this person becomes your biological child. He or she becomes your child, but not for the other parents or not for the other biological parents. Now you assume all the duties and responsibility of a parent as a biological parent. So adoption is permanent. Adoption is permanent, and it's for the whole lifetime of this child, whereby even in succession, upon the demise of the adoptive parent, this child will still acquire his or her right as a child of the deceased parent, deceased adoptive parent. So where can a person apply for adoption in Uganda? A person can apply for adoption in Uganda through the following authorities. A01, Chief Magistrate Court, if both the applicant and the child are citizens of Uganda. Meaning if you are Ugandan and you want to adopt a Ugandan child, you can file your application in the Chief Magistrate Court. Ugandan adopting a Ugandan, you can file your application in the Chief Magistrate Court. But if the applicant, that's the adoptive parent, is not a Ugandan, or the child whom you want to adopt is not a Ugandan, you file your application in the High Court of Uganda. So that is provided for under Section 44 of the Children's Amendment Act. So a child need not to be a Ugandan to be adopted in Uganda. As we said, as we said in our previous videos on my YouTube channel, that a child is a person who is below the age of 18 years. Yeah. And it does not mean that for you to adopt a child, he or she must be a Ugandan. No, as long as that child is in Uganda and he or she is being raised in Uganda, you can adopt that child. Let's continue with our discussion. So what are the requirements for adoption? The requirements for adoption are as follows. 1. The applicant or one of the joint applicants must have attained 25 years of age and be at least 21 years older than the child. So the applicant must be 25 years and above and 21 years older than the child. You get my point? You cannot be 20 and you want to adopt a child of 5 years. You cannot, because you're not 25 and above and you're not 21 years older than the child. So that's the first requirement, that you must be above the age of 25 in order for you to adopt a child in Uganda. In the case of an application by one of the spouse, the other must consent to the adoption. Let's say you're two married couples you're a married couple, man and woman, and the wife is like, me, I want to adopt this child. It's not a joint applicant, but only the wife is the one who wants to adopt the child. If the wife applies for adoption, the husband must consent to the application. So there has to be consent in case of married couple or married spouse who wants to adopt. So the third requirement, for an unmarried applicant may not adopt a child of the opposite sex save for exceptional circumstances. So if you're there, you're a man or woman, you're not married, and you want to adopt a child of an opposite sex, a child, let me say you're a woman and you want to adopt a child, it's minimal, or your application might be rejected unless there are exceptional circumstances. So exceptional circumstances include when, like, there is no any other option to take care of this child, or the child has, because all these matters are decided for the interest of the what? Of the best interest of the child. That's why court, in every children's matter, they follow the welfare principle. So there has to be exceptional circumstances for an opposite and for someone to adopt a child, but when that person is not married, to adopt a child of an opposite sex. Yes. So a prospective adoptive parent must have fostered the child for at least 12 months under the supervision of a probation officer, save in exceptional circumstances. So if you want to adopt a child, you must have fostered that child for a period of 12 months. 12 months is 1 year. You must have stayed with that person for a period of 1 year. But if at all there are exceptional circumstances, as we've said, that court always looks at the best interest of this child who is going to be adopted. The 12 months period might not be put into consideration depending on each and everyone's case. So let's continue with our discussion. A probation and social welfare officer is required to submit a report to assist the court in determining the application. Remember, we've said when you're fostering a child, you're fostering that child under the supervision of a probation officer. So after the 12 months of fostering this child, the welfare officer, the probation and welfare officer, goes ahead and writes a report to court showing how you've been taking care of this child. Are you a good person for adoption? And so on. So this report helps court to determine your matter either in your favor or not in your favor, depending on the circumstances. So except for spouses who have applied jointly, like two, as I said, married people like man and woman have applied both to adopt the child, an adoption order cannot be made authorizing more than one person to adopt a child at the same time. So for you to apply for a joint adoption, you must be married couple. You must be married, like man, husband and wife. Court cannot grant a joint adoption order to two different people. Like maybe someone is coming from Masaka and another person is coming from Mbale, but those people are not married. They are totally different. They don't even sleep in one house. No. Court grants a joint adoption order to only and only married couples. Yes. Let's continue with our discussion. So a person who is not a citizen of Uganda may, in exceptional circumstances, adopt a Ugandan child if he or she fulfills the following conditions. So the other conditions are for a Ugandan citizen, but now we are looking at the conditions for that person who wants to adopt a child in Uganda, but that person is not a Ugandan or is not a Ugandan citizen. These are the things you must fulfill in order for you to be granted an adoption order. 1. that person has stayed in Uganda for at least 1 year. That is, those are the 12 months, 1 year. 2, has fostered the child for at least 1 year under the supervision of the probation and welfare officer. That's what we said even for Ugandans, so that requirement is the same. Does not have any criminal record. So, does not have any criminal record. This recommendation will come from his country, his or her country of origin, saying that you have a clean record. Another requirement is that has a recommendation concerning his or her suitability to adopt a child from his or her country's probation and welfare officer or other competent authority. So after you getting the recommendation of no criminal record, you have to get another recommendation from a probation and welfare officer of your country indicating that you are a suitable person for adoption, that you can adopt someone and you can take good care of this child as your own child. Another requirement is that has satisfied the court that his or her country of origin will respect and recognize the adoption order. You have to to prove to court that your country is going to respect the adoption order, which is going to be granted to you as an applicant. So all this can be found under section 45 and 46 of the Children's Amendment Act. So the intercountry adoption